If you are at fault in a car accident and you're sued, you stand to lose a lot. Can the other person take your home or your wages? Find out in this video. Getting into a collision on the roadway can be stressful. You may have to deal with injuries and repairs to your vehicle. The other party believes that you're at fault for the car accident. They may try to make a claim against you or file a lawsuit against you seeking monetary compensation. And that can drag the stress out for even longer and put you in a precarious financial situation. But before anything can be collected from you, the other party has to actually win a lawsuit against you in the case. This means they must demonstrate in a court of law the following facts. 1, the accident in question actually occurred. 2, that you were at fault for the accident. And 3, that they suffered specific damages due to injuries from the accident. If the judge or jury believes that the other party, who is known as the plaintiff, proves these facts successfully, they may decide in the plaintiff's favor. They also decide how much to award the plaintiff. The plaintiff then becomes what is called a judgment creditor against you. They hold the same position legally that a credit card company that sued you for a past due balance and won might hold. In short, you legally owe the money awarded to them, and they can use legal means such as wage garnishment to collect that money if necessary. Well, you might wonder how much protection insurance offers in this case. Your insurance company should pay out before you do. That means it will pay up to the limits of your liability policy before you personally pay any amount of an ordered judgment. For example, say you're found at fault in a distracted driving accident and your liability policy has limits of $100,000. If the plaintiff is awarded $50,000, the insurance pays the total amount and you have no further obligations in the matter. However, if the plaintiff is awarded $150,000, you would owe a remaining $50,000 after the insurance pays out your maximum policy limit of $100,000. At this point, the plaintiff can exercise legal rights to your property. They may be able to compel you to hand over cash or sell certain property to make payment on this debt. Some assets are exempt from being taken by judgment creditors. For example, the homestead exemption in Nevada protects your primary home as long as you don't have more than $605,000 in equity or ownership in the property. This means in most cases you would not be required to sell your home to make good on a debt related to a lawsuit. This exemption does not apply to other properties such as second homes, rental properties, or vacation properties. The same is true of your vehicle up to $15,000 in equity. So, for example, if you have a vehicle that is valued at $25,000 and you're paying on a loan with a balance of $18,000, the vehicle would be exempt. It only has equity of $7,000. Other assets that are exempt include most retirement funds, including Roth IRAs, value in 401k plans, and pensions, as well as a certain amount in household goods and furniture. Life insurance payouts and government benefits such as Social Security payments are also exempt. Court-ordered alimony or child support is exempt. However, any voluntary money provided by your ex outside of a court order is not exempt. Plaintiffs who have won a judgment against someone after a car accident can work to collect the money through all the methods and means other creditors have at their disposal. That includes setting up agreements for regular payments. If someone can't cover the total judgment amount, plaintiffs might agree to accept regular monthly payments over a period of time until the amount is paid off. Garnishing wages. The individual may file a motion to garnish your wages. They can take up to a certain amount of your disposable income. Typically, the garnishment is filed with your employer and your employer takes the amount out of your paycheck before you receive it. The employer then forwards the amount to the judgment creditor or their agent. And 3, levying your bank accounts. If you have cash in checking or savings accounts, the judgment creditor might file a motion to levy those accounts and take your money. The only time this is not true is when the cash in the accounts is part of an exempt benefit, such as court-ordered child support or government benefits. Whatever side of a car accident case that you fall on, don't waste time and put your interests at risk. And don't hesitate to reach out to me to discuss any questions that you may have. And remember, if it's about you, then it is high stakes.